Hi there. Thanks for joining us here on Bloomberg Quint. You're watching Insolvency Diaries, and on the show today, we'll cover two important developments. First up, at the end of this month, the Insolvency and Bankruptcy Code will be staring at a 6-month suspension. As you all know, the government, via an ordinance, had suspended the bankruptcy law for all defaults post March 25th for a period of 6 months. The ordinance also gave government the power to extend the suspension by another 6 months, that is, until March 2021. So, is this further suspension a good idea? The second development has to do with the bankruptcy regulators' recent proposals to create a market for illiquid assets of companies under liquidation. Will the regulators' suggestions make the liquidation process more commercially sound? To talk about both these issues, I have with me R.K. Bansal of Edelweiss ARC and Nikhil Shah of Alvarez and Marcel. Gentlemen, welcome to Insolvency Diaries. Mr. Bansal, I'll come to you first. To your mind, has the IBC suspension proved useful for corporate India, or has it proved to be an artificial life support for companies that were already under distress?
I think we need to understand two things. First of all, the suspension of IBC was not for those companies which were already in distress. The suspension of IBC was specifically for those companies which are defaulting after, let us say, February end, and it's a COVID-related default. So certainly, if it was in default before February end, the suspension rule doesn't apply. So it is not for those companies which were already in distress, first of all. The suspension was meant only for the companies which are facing problem because of COVID. The other issue, of course, is because of suspension, what is happening is, because of COVID, IBC and NCLTs, they are not working actually, courts are not working full-fledged. Either they are working from virtual space. So anyway, there is a delay in admission of the old cases also. So on practically, if I say, yes, suspension is applying even to old cases because NCLTs are not admitted. But legally, the suspension is only for the new cases which are defaulting because of COVID.
Okay, Nikhil, let me come to you. The RBI's moratorium has come to an end on August 31st, and now there's a new restructuring scheme notified by the regulator for companies facing stress specifically because of the COVID-19 pandemic. The scheme will allow lenders to restructure those accounts that were not in default for more than 30 days as of March 1st. Given that this scheme is now in play, is it imperative for the IBC to remain suspended?
Hi, Payaswini. Firstly, thank you for having me on your this webinar. I just want to actually first add to what Mr. Bansal was saying in terms of the cases, the suspension of the IBC to begin with. I have some statistics. As of September 19, there were 13,000 applications that had been submitted to various NCLTs across the country that were related to triggering an insolvency process. Of that 13,000, 10,800 applications are actually still pending admission. That can give you a picture in terms of the backlog which Mr. Bansal was speaking of in terms of admitting cases. And this is obviously prior to COVID, prior to the courts not being able to function in the same manner as they were before. And so the fact that new cases post March 25th have been suspended may actually be a blessing in disguise as well, because there's already a huge number of cases that are pending admission. And secondly, I'd like to also point out that the fact that in our system in India, when there's a default, effectively what happens is that the board gets suspended, and the existing shareholders and promoters are also suspended from and don't have control over the operations of the company. Moving forward, it moves to the resolution professional and the creditor committee. Given that dynamic, which is different than in other jurisdictions where the corporate debtor continues to drive control of the business, even in a bankruptcy or insolvency process. Here, because COVID is a situation that hasn't been created by anybody, by borrowers or lenders, but has obviously significantly impacted their operations and them financially. Should they be allowed to go into an insolvency process in India where they effectively will lose control and the value of their companies as well? And so I think that given that background and the fact that there's a large number of cases that are pending as well, that the suspension probably was a good idea for the first 6 months. Whether it should get extended or not, I think is a function again of the ability of new cases to be admitted, so that there can actually be a resolution of those cases. But that requires the courts to be working, and requires them to be working, virtually, and allow for the applications to be admitted so that cases can actually, start, which has been a challenge, for some time. Coming to your question on whether the moratorium, what is the impact of the moratorium being lifted, and the scheme that the RBI has come up with in terms of allowing for a one-time restructuring, I think that it's a good idea that the RBI and government have come up with a scheme that allows for companies to reschedule payments up to 2 years under this scheme. So I think that the objective is good, that there is a mechanism in which companies that have been impacted by COVID, where their cash flows have deteriorated because of the lockdown or because of the demand situation, and are not able to pay their lenders on time, have a window in which they can actually reschedule those payments to match when their cash flows do actually come back to pre-COVID levels. However, I have to state that there are a couple of conditions with the scheme which may make it difficult to implement. Firstly, in the larger companies, there tends to be multiple stakeholders in the capital structure other than just banks and NBFCs. Those could include insurance companies, pension funds, mutual funds that are not governed by this RBI circular. And the first, way to avail the scheme actually is that all of these different stakeholders have to sign an intercreditor agreement within the first 30 days, which has been difficult to achieve prior to the scheme being launched. There was a previous scheme which is still in effect, the June RBI circular, and we've seen very limited cases where all of the stakeholders have signed the intercreditor agreement. If they don't sign the intercreditor agreement in time, they can't avail of this scheme. The second issue that we see, which may be problematic, is that the restructuring agreement or resolution agreement between the stakeholders in the company needs to be signed by December 31st in order for it to be implemented. In the larger cases where there may be 10 or 20 different lenders that are involved, it's quite difficult to go through the process in, let's say, 2.5 months, which would be the time frame available till December 31st. And of course, after the KV Kamath expert committee were to come out with its recommendations on the parameters to be used in using this restructuring scheme. So all in all, I think the objective is good. I think that there are some challenges practically in implementing it.
Sure. Thanks, Nikhil, for laying out, the impediments in the implementation of the RBI scheme. And that gives me a segue to go to Mr. Bansal. Mr. Bansal, given what Nikhil has pointed out in terms of, the RBI scheme becoming difficult where, you have a large group of creditors on the one hand. On the other hand, like you said, because we have pendency dating back to a year ago, cases which are pending admission that were applications that were filed a year ago. In light of that, IBC potentially should be, like you said, continue to see suspension. How do you see this COVID debt getting resolved in that case?
I think just start here. Start with this, that we are discussing COVID debt, but actually the problem to some extent the pending cases or the lot of cases which are not getting admitted in IBC is basically pre-COVID. So I'm just trying to say that we are talking of both types of cases in that sense. Now coming to your, see the COVID-related default and that how to resolve that. Now, so let me say that there are two parts of the problem. One, the cases which were already in distress as on 1st March 2020 and which have not got resolution because either they have not got admitted to IBC because of the infrastructure constraints, or banks have not been able to resolve even under the June 19 circular because of the ICA related issues. Part is now the new cases which are coming through and which are because of COVID. So the first part, the old cases, I think we are not discussing as of now. Let me say that those cases, some of them are getting resolved. Again, after this suspension, after courts start working, they will start getting admitted to IBC or banks will find a way out. We were in fact hoping that RBI will relax something on the restructuring guideline when they announced this, but that has not happened because RBI has announced this restructuring only for, again, COVID-related defaults. That means the case has to be maximum SMA 0. So maximum 30 days default as on 1st March. So that means standard and cannot have the type of distress which was there before this date. All these three things actually we have to look into jointly. One, the moratorium announced by RBI. So let's say for initially for 3 months and another 3 months, so 6 months. And same 6-month window was initially decided for IBC suspension. Now, after that, RBI came out with a restructuring, which allows them 2 more years to be given for reschedule. So actually, if you add this 6-month moratorium and 2 year, you can do reschedule. Technically, you are doing virtually 2.5 year moratorium. Okay. And this IB suspension was also added because if the companies are defaulting during this period, these companies should not be referred to IBC. Though my personal view is even if they would have referred, they would not even got admitted because neither the courts were working nor they have the infrastructure to admit these cases. And even otherwise, banks are, if today a client defaults, in any case, banks take time to refer a company to IBC. It's not as if today company has defaulted and we will refer the company in 1 month to IBC. So in any case, 1 or 2 years would have passed. So what I'm saying is, in that case also, these three things are taken jointly. That RBI gave 6 months for moratorium. Then when 6 months were getting over, it came out with a restructuring circular. And you can do the restructuring by which you can grant 2 years more moratorium. IBC will go slow for some more time because of the infrastructure constraints. Also because of COVID, what is happening is today you may not find buyers or you may not find strategic investors for some of these cases unless the value goes down very substantially. Because the buyers have also got impacted because of COVID. If want to sell, let us say, is power plant today or steel plant, we have to look towards the power producers or the steel manufacturers only. And many of them have got impacted in this process also. It will take some more time that we can get a resolution through IBC. So I think, coming to your question whether we should extend it by another 6 months, government intention was, I think, in the beginning also to make it 1 year. And now that COVID is getting extended, I mean, the COVID impact itself is getting extended and the pandemic is not really going away immediately. I'm pretty sure that this 6 months will get extended to 1 year.
So how do you, some of the concerns, Mr. Bansal, that Nikhil pointed out, right, that there is a set of creditors which is clearly not covered in the RBI restructuring scheme. They don't have recourse to IBC. How does that get resolved?
That can be resolved through ICA partly, or finally, if banks and these institutions can't come together. See, let me understand also one just to clarify. Most of these issues, actually, these companies or these mutual funds, insurance companies, provident funds, they are either in the NCDs, public issue of NCDs, or they will be, you will find them maybe in some NBFCs or some promoter type funding. Whether, I mean, when you lend against the shares. So I think that type of category, even otherwise, I find it very difficult to resolve through IBC. financial sector entities in any case are not allowed unless we can refer to that section 241 or something where RBI has to agree. And you would have read RBI suddenly recently two companies to be referred to IBC, which are in the financial sector. So because IBC is not really a good mechanism for financial sector entities, you put a moratorium and after that clients also start defaulting. So the resolution for financial sector entities has to happen fast. It has to happen immediately rather. So I think most of these issues are not that much in manufacturing type concerns which are normally referred to IBC. But yes, what Nikhil is saying is relevant in some cases where nowadays people borrow from every type of entity, whether it is insurance company, whether it's mutual fund. In that case, ICA is the only, I think, mechanism by which we can do a resolution. Or you finally go to IBC if you are not a financial entity.
Yeah. Nikhil, tell me this. This is one argument that, people have been, putting across since the government's decision of suspension of IBC. And that is that why not allow companies to do voluntary filings? That even if, let's say, you want to put or check actions by financial and operational creditors, a company surely can assess whether or not, IBC is the right route or an RBI restructuring scheme is the right route for it. In this extension, should this equation of voluntary filings change at all?
I think that the company should have the right to actually choose if it wants to admit itself into an insolvency process. I mean, that is, the company has the best view in terms of its cash flows and what its liabilities are and how it can service or not service them. And so if a company chooses to take the drastic step of filing for insolvency, I think that the government should allow that to go forward.
Sure. Mr. Bansal, any thoughts on this, or are you also in favor of the government probably reconsidering Section 10 filings once, if at all, this extension comes through?
I agree. I think corporate itself feels that I cannot survive without insolvency. They should be allowed to file. Only thing is what has been happening is sometimes the government or everyone gets worried that some of these corporates who are filing on their own, they could be trying to arbitrage the benefits of IBC system rather than actually really going through the insolvency. So I don't think if you will find many applications filed under this section voluntary insolvency, I don't think any corporate has filed except one or two. But those who file, they're very small entities and they just want to take the benefit of some maybe statutory liabilities or taxation liabilities, getting rid of that. In India, typically wants insolvency and very difficult to make them understand that you are insolvent and filed IBC.
Okay, understood. So the consensus emerging from the both of you is clearly that the government should extend the suspension of the IBC for the next 6 months and probably, make the extension less stringent by allowing voluntary filings. The second development I'd like your thoughts on is the recent proposal by the bankruptcy regulator on the liquidation process. The IBBI has proposed that liquidators should be allowed to transfer full or partial interest in illiquid assets, like sundry debts, including refunds from government and its agencies, contingent receivables, disputed assets, and assets underlying avoidance transactions. Nikhil, how big is this problem of illiquid assets presently?
So I think it's actually not only illiquid assets actually that the government or the regulator should look at in terms of changing the provisions. We feel that, and Mr. Bansal can confirm this, that in liquidation cases, it's taking a very long time for, in fact, very few cases where creditors have actually realized value through the liquidation process. In most of the cases, they've been mired in a lot of litigation. And also the liquidators, probably not doing a very good job in terms of auctioning those assets and actually providing the realization of those proceeds to the creditors. And so our belief is that in order to really improve the efficiency of the system, that the ability for the liquidator to sell any of the assets together, whether it's liquid or illiquid, as quickly as possible to consolidators or people who are willing to put up consideration in cash to the benefit of the creditors. I think that would be a very positive move.
Okay, Mr. Bansal, could you weigh in on how big is this problem of illiquid assets, and would it benefit the, let's say, the existing creditors if this sort of a market is created?
I agree, but as of now, let me just add, as Nikhil is, I think, if I understand what he's saying, today even liquid assets we are not able to sell. So when we talk of liquidation, we are supposed to sell the asset which can be easily sold, like say even, immovable assets or even goods or stocks or machineries. But I think overall where orders have been passed for liquidation, which is almost like something like 700 or something, I think, I don't remember the exact figure. There are only 57 cases which have got liquidated, as per the last data. And out of this 57 also, mostly were those cases where there were no assets. Okay. So you could just strike off their names, dissolve the company, right? In many cases, though, the timeline for liquidation is 1 year, but it's not really happening in many cases because, one, we keep on still finding a lot of, I think, problems being created by some vested interest here and there. Secondly, the liquidation value, which is given by the valuer, I think is not in tune with the market reality. I'm not taking into account this COVID impact. This COVID has again impacted the whole thing, but I'm talking about the situation before that. So the valuation, so what happens is then liquidator can reduce it only by 10% or so at a time. That process itself sometimes goes on. So one is there is a not big market, and today after September 18, when the liquidity was less in the overall system because of the NBFCs, because of the real estate not doing well, the market for distressed assets, and when we talk of liquidation, we are virtually talking of piecemeal liquidation, right? So has been quite low. So we have not been able to realize, liquidators have not been able to realize even the so-called liquid assets. So it takes time, but it will happen. Now coming to the illiquid assets, these are basically claims, counterclaims, arbitration awards or likely to be awarded, dues receivable from the government, etc., etc. Now many of these in any case are being fought in the courts. So basically we are talking about whether we can sell these claims. This market has to develop. This market will be there last, but unlike maybe the other countries where the contract is honored, or at least by the government it is honored, here we find most of these claims are against government entities or government also. So it will be very difficult to realize that. But yes, if somebody is ready to buy, and as I think there have to be some legal firms who are ready to do this, like what happened in UK. And there are other entities also who can start buying these claims so that liquidator can get rid of these assets in one stroke. But getting full cash and buying these assets, it will take some time. So it's a futuristic scenario. I would say IBBI has done a good job in putting this paper for discussion, but it will take at least, 3 to 4 years just to start this market. As of now, I think when selling liquid assets is difficult, finding buyers for illiquid assets will take time, but you can do along with the recompense clause. I think that is what IBBI has put. Either one is full-fledged sale, or you just give some now and then keep on realizing and then share in the profits.
Yeah, I suspect the valuation overhang will play its part in such transactions as well. Nikhil, the regulator has also proposed that creditors be allowed to transfer their debt at the liquidation stage for both transfers, let's say by liquidators of some of the actionable claims and creditor debt. What kind of transactions or activity can we accept if these proposals become a reality? Are there any focused funds that might look at this as an opportunity?
Yeah, so to start off with, I would say that the financial creditors should have the right to sell their debt at any time. Actually, if they choose that is the best course of action for them to exit an account and or drive the best recovery or other considerations in terms of time, they should be allowed to do that at any point in time, and there should be no restriction in my view. The second is that will this actually provide a quicker exit by allowing for these illiquid assets to be sold over to be monetized over a period of time? Yeah, I think that by allowing somebody to take over these claims and provide the litigation funding that is needed in order to realize the value of it is actually widespread in the US and Europe as a mechanism, and that mechanism is also seen the light of day here in India in a few cases that I'm aware of, like for example in Patel Engineering, which was not an insolvency case but was a restructuring case that took place, and a fund came forward and is basically funding the litigation in terms of recovering these claims from various government agencies over a period of time, and is providing the funding for that and is recovering first percentage of recovery, and then the balance is going to the financial creditors in the case. So there are some examples of where it's already happening here in India, not that we've seen in liquidation per se, but as a concept, yes.
Okay, sure. Mr. Bansal, both the liquidators and creditors, as per the proposals, will not be able to assign these illiquid assets to entities that are disqualified as per Section 29A of the IBC. If and when this market picks up, will that prove to be an impediment?
Should not be, because that is a standard, I think, thinking process of the government, that the promoters, the entities which are covered by Section 9A, should not be allowed to buy back the company's assets, which is the same rule in normal liquidation of even selling plant and machinery. Maybe at some stage we may have to relook at it, because some of these claims actually perhaps can be handled better by the existing promoters. But as of now, I would say, because of the, I think, overall issues related to IBC itself, insolvency, I think government thinking is on those lines only, that existing promoters should not be allowed. So Section 29A, maybe after we become mature enough, we can think of relaxing this 29A, especially in these claims and all that.
Okay, Nikhil, does leniency on Section 29A front need to come from day one in this case, or as Mr. Bansal pointed out, let that market develop and maybe then we can review promoter participation?
My personal view is that the existing promoters should be allowed to actually pursue those claims, because as Mr. Bansal indicated, they have the most knowledge and background actually of the situation of those claims, and and it should be done on a transparent basis, that they should be an interested party who is bidding like anybody else. And if they're willing to offer more value, and the creditors and liquidators are happy with that value, then they should proceed. They should be allowed to proceed with that, in my view.
All right, Nikhil, Mr. Bansal, thank you for joining me here on Insolvency Diaries and your views both on a potential suspension of IBC for the next 6 months and this new market that the regulator is trying to achieve for illiquid assets of companies facing liquidation. Thank you for joining us here on Bloomberg.
Thank you.
Thank you so much.
Nikhil, and thank you.
Thanks, Mr. Bansal.